Welcome, Dr. Shetty, to Editor Speak. Sir, can a doctor take a defense in a medical negligence case that if he has not charged while treating, he does not come under the ambit of the Consumer Protection Act 1986?
First and the foremost, doctor should be aware that the relationship of a doctor and a patient is a relationship of contract, where the doctor is a service provider and the patient is a consumer. For this relationship to be complete, there should be a legal consideration called as fees.
Right.
It is the choice of the doctor to either take the fees or provide free treatment. But using free treatment as a defense in a case of negligence will not be advisable.
Sir, so what will be the opinion of the court in a medical negligence case if the breakup of the hospital bills reveal that fees was not charged by a particular doctor?
That is a good question. A recent judgment from the National Consumer Commission has provided a lot of clarity in such a scenario. In this case, a child was brought to a vascular surgeon who diagnosed a AVM. Arteriovenous malformation embolization was performed. The patient ended up with gangrene, for which above knee amputation was performed in another hospital. The relatives of the patient filed a case of negligence against the vascular surgeon. In one of the defenses by the vascular surgeon, he stated that he had provided free treatment and not charged his fees, which was further confirmed by the breakup in the bill of the hospital, and hence he was not under the ambit of the CPA 1986. The court rejected this defense outright. The court stated that the patient's relative had paid the fees, which was a consideration to the hospital, and that is the consideration of the vascular surgeon also. Hence, the court held the vascular surgeon and the hospital negligent.
Sir, so what would be your advice to doctors based on this judgment?
My advice will be, let the doctors not be under the misconception that providing free treatment can get them out of the ambit of the Consumer Protection Act. But the law is still not clear about this. There's a lot of ambiguity. Hope future judgments will provide better clarity, and doctors should be aware of the same.
Sir, hope our doctors realize that the standard of care that is important and not the charges while deciding the fate of the doctor in the court of law. Thank you.